Hi, welcome everyone, and thanks for your patience. This is our workshop on navigating the EU Digital Services Act, implications for innovation, privacy, and collaboration. I'm your moderator today. My name is Emily Laidlaw. I am a Canada Research Chair in Cybersecurity Law and Associate Professor in the Faculty of Law at the University of Calgary. Bit of a mouthful. I am delighted to kind of walk you through the agenda today. We were going to have opening remarks, and I will introduce those speakers shortly. And then we will have a setting the scene discussion followed by a panel discussion. And then it opens up to you, and you can ask questions of the panelists. So I will jump right into it and introduce our speakers for the opening remarks. Welcome Konstantinos Kapsaropoulos. He is the Digital and Science Counselor for the delegation of the EU to Canada. I also welcome Blair McMurran, Associate Assistant Deputy Minister for Cultural Affairs, Canadian Heritage. And Christian Hansen, he's the Regional Director General, Pacific Region for Innovation Science and Economic Development. And I would also finally like to welcome Nadia Sheikh Neem. She is the VP Programs for Digital, which is Canada's Global Innovation Cluster. Thank you, everyone, for coming today and joining us. Kostas.
Thank you, Emily, for the introduction. Good morning to those who follow us from the west coast of Canada in British Columbia. Thanks a lot to all of you who follow us from the east coast and Europe. I'm very, very happy to open this webinar on navigating the EU Digital Services Act. This webinar follows up on a series of activities that the European Union delegation in Canada is undertaking in order to dispel the myths about the Digital Services Act and to show how it can work for innovation. I would like to thank very much for their support the Canadian Heritage, the ISET, and especially the regional branch, which is with us, and of course, Digital Supercluster, because it is with them, with you guys in the Digital Supercluster, that we are co-organizing this webinar. And I would like to thank all the panelists and all the participants today, and I will not keep it very long. I'm very delighted that we're having this series of webinars around Canada.
Thank you. Kostas, I realized too that I jumped right into it kind of with the flurry, and I didn't do kind of the important first job I wanted to do, which was to provide the land acknowledgement. So if we can just take a second to do that. I am based in Calgary, and so I'll introduce you to a bit of where I'm from. Located in the heart of southern Alberta, and I'd like to acknowledge and pay tribute to the traditional territories of the people of Treaty 7. And that includes the Blackfoot Confederacy, that's comprised of the Siksika, the Piikani, and the Kainai First Nations, the Tsuut'ina First Nation, and the Stoney Nakoda, and that includes the Chiniki, Bearspaw, and Goodstone First Nations. Goodstoney First Nations, pardon me. And we're also home to the Métis Nation of Alberta, Districts 5 and 6. So that is my second welcome to you all. What I'd like to do is turn to some opening remarks from our representatives from the Canadian government. So Blair, if I can turn to you first.
Okay, thanks very much, Emily. Can I just make sure my tech made the transition? You hear me?
It sure did.
Yep, okay, that's great. Yes, thank you. And thank you, Kostas, for the opening as well. I'm very happy to be joining today's webinar and this series of webinars on a really important topic, one that the Government of Canada is very invested in, as I'll say a bit more about in a moment. I'll just say, I'm Blair McMurran, the Associate Assistant Deputy Minister of Cultural Affairs at the Department of Canadian Heritage, coming to you today from Gatineau, Quebec, in the National Capital Region, which is the traditional unceded and unsurrendered territory of the Algonquin and Anishinaabe people. So as I said, I'm with Canadian Heritage, part of the federal family that cares about this issue. But in our case, we've been given leadership of Well, a number of digital policy files, including online safety, which is the angle I'll sort of come at this about, but I'll talk a bit more broadly to start with. As Canadians, I think, as we all know, Canadians rely heavily on digital platforms for news, for information, and cultural content. Um, for that reason, our department's been leading efforts to develop regulatory frameworks around this space, that are impactful and adapted to the realities of the digital age and, the way in which Canadians seek out and find and discover and consume content online. So that has guided a few fairly major legislative initiatives. For example, like through the Online Streaming Act, also known as C11, the government has empowered our broadcast regulator, the CRTC, to require online platforms to contribute financially, like to the ecosystem for creation, production, and distribution of Canadian narratives, stories, music, cultural content. Through the Online News Act, also known as C18, we established a framework for mandatory bargaining between digital news businesses, well, not just digital, I should say all news businesses and digital platforms, large ones in particular, ensuring fair compensation for the value that news outlets generate, like for platforms and other players in the digital media ecosystem in Canada. So these are two examples. I would describe them as major, as I just did, major legislative initiatives. These are adopted and law in Canada, and the implementation of them continues. So these are efforts to strive to safeguard strong, diverse, and independent broadcasting and news media sectors, and ultimately to produce content and information that Canadians can trust. I believe we're well down that road. But as I think all of us also know, the influence of digital platforms extends beyond the health of our media and our creative ecosystem. And despite their considerable benefits to our society and economy and the way we all live, digital platforms do pose complex challenges to the safety and the well-being of the people who use them. We're far from being alone in facing these challenges, and that's where today's webinar comes in. International initiatives like the Digital Services Act in the European Union have greatly inspired our work in Canada on these issues, and in particular, the issue of online safety and combating online harms. So I would say, we would say as the government, the Digital Services Act broke new ground, and that's why we look to it by setting transparency requirements and risk mitigation obligations for digital platforms. And its adoption effectively marked a new era globally in platform accountability and governance. In February 2024, and I think many of you will know this. If you don't, I'm just painting a picture. The Government of Canada introduced the proposed Online Harms Act, the third of these digital bills I was talking about. This one was not adopted. It died on the order paper due to the prorogation of Parliament in January of this year, 2025. But there was a lot of civil society and expert consultation that went into this legislation. And its design included legal obligations on social media services to reduce users' exposure to harmful content. So as I said, the Digital Services Act was a source of inspiration. Not all elements of it were deemed appropriate or workable in a Canadian context. I'll say that, like in a sustained conversation with Canadian experts and international. So things like the regulation of disinformation online, it's not part of our framework. And the European framework is broader in terms of the services that are regulated. But there were aspects that were absolutely looked to as a gold standard, and these were things like the risk-based framework used by the Digital Services Act and its provisions for allowing accredited researchers access to data under the framework for the production of good public policy and information about what was being achieved. So although the Online Harms Act did die on the order paper, it laid an important foundation for future work. And as such, lessons learned from the Digital Services Act and its implementation are going to continue to guide the Government of Canada as we consider the way forward on online safety, which is very actively being reflected on and discussed. Today's webinar is going to help you better understand and navigate the European Union's framework and to do business in that context and to pursue your own activity. But I guess I would invite you to take this opportunity at the same time to reflect on the EU framework from a Canadian perspective and the potential benefits and impacts and other consequences we might want to be aware of adopting a similar approach in Canada, and we'd welcome your feedback on that count. As a government, I will say, like, we are committed to unleashing the full power of Canadian innovation and innovators. This is a core principle, and this commitment does drive us as we work to develop frameworks for digital platforms that foster a thriving creative economy, protect and respect copyright, and above all, keep Canadians safe when they are online, to go back to that issue. So discussions like today's, together with our ongoing collaboration with the European Union, which we value very much, are going to help us shape the path forward for Canada. We look forward to engaging with you in this work and do sincerely invite your engagement, during today's webinar and after, as we pursue this issue in a potential legislative context during this Parliament, if I can put it that way. So thank you very much. I'll pass it back, I think, to Emily.
Yes, thank you, Blair. I appreciate that, and that it's the file continues to be a priority for Heritage Canada. So I'm going to turn now to Christian Hansen from ISED.
Good morning, everyone, or good afternoon, depending on where you are. I'm Christian. I work at Innovation, Science and Economic Development in Vancouver, la plus belle ville au monde, peut-être la plus chère. Donc, bonjour tout le monde. I'm happy to share some opening remarks with you for this event. I think I was asked because I'm proximate to the digital supercluster and that we're all in Vancouver, but also because I had the honor of representing Canada in Brussels for 4 years, a long time ago, and I got to work on privacy issues. I learned a lot about the European Union, and I have to say that it's a continuously evolving set of institutions. I once heard it described, I heard Brussels described as a lawyer's paradise. I have to say, I agree with that assessment. I just want to note that for a Canadian audience, the European Union is a set of institutions. It involves a lot of actors, and when they can come together, they can create powerful legislative instruments. So in today's case, we're talking about the DSA. I just want to point out that this is a regulation. And for those that don't know what that means, it means that it automatically becomes law in all member states. So the EU's ability to legislate like this, again, is quite powerful. And all we need to do is look at the influence that the GDPR, for example, has had on how we conduct ourselves online to see what influence this can have. I also want to mention that consumer protection is something that's very much on my mind these days, professionally, but also personally. You may have seen a CBC Marketplace story on a gentleman in Victoria, here in British Columbia, who was defrauded of $1.7 million. The story ran this week. That's my friend's dad. And so my friend just lost his inheritance. So consumer protection really needs to be at the heart of how we think about transactions in our society, both in person and digitally. Now, I'd love to stay with you for the rest of this event. Unfortunately, I can't. My office today is organizing another event on industrial and technological benefits. And if anyone wishes to speak about ITBs, which is a fascinating but arcane topic, I'm at your service, and I wish you the best in today's discussion. Thanks very much.
Thanks so much, Christian. I read about that story. It's just horrifying. And I think that how to deal with online scams is kind of one of the key issues, isn't it, for the coming years? So for the last for our opening remarks, I would like to welcome Nadia.
Thanks, Emily. It's such a pleasure to be here. Who would have thought I'd be so excited to talk about the Digital Services Act, but I am. And so I'm here to talk about the Digital Services Act and how, from the BC perspective, the opportunities that it opens for us. So at Digital, we bring Made in Canada digital solutions to market by connecting technology builders and enterprise buyers. And so this work reflects this broader commitment that I hold pretty dear, which is unlocking commercial pathways for Canadian innovation and ensuring that our technology is built to compete and lead globally. And that's why EU's Digital Services Act and the AI Act matter. These aren't just European regulations, they're global standards that define trust, transparency, and accountability in the digital economy. And that directly affects how we build technology, not only here in Canada, but across, not just in British Columbia, but across Canada. Canada and the EU share a real opportunity, not just to set the rules, but to lead with values. And so today I wanted to discuss what this opportunity really looks like and speak to why BC and Canadian tech companies need to see the DSA as a roadmap for building better, more ethical, and more globally competitive digital solutions. And so I'd like to talk about three key areas right now. So the first is platform accountability. So the DSA pushes for clearer rules around content moderation, user protections, and for BC companies, especially smaller ones, this is a chance to stand out. By building platforms that prioritize user safety, transparency, we earn the trust and to compete globally. And yes, compliance takes effort, it takes investment, but it also builds credibility and opens doors to new markets. Second, I'd like to talk about transparent algorithms. And so the DSA calls for more openness in how algorithms work, especially in recommender systems. And this is a strength for BC that we need to sort of lean into. We're already leaders in ethical AI, and by designing systems that are explainable and fair, we're not just meeting regulations, we're building tech people can trust and understand. And third, my favorite topic, which is data governance. The EU standards on data protection are high. And while our Canadian frameworks like PIPEDA share similar goals, there are important differences in scope and reach, and Blair sort of touched upon them a little earlier on. And Canada has an adequacy status with the EU, which allows data transfers between our jurisdictions. However, the EU standards around consent, user rights, and enforcements are stricter. And for BC companies, aligning with these higher standards is a strategic move. It ensures that our products are ready for the European market and makes us attractive partners for global collaboration. So in closing, I hope that we see DSA as more than a set of rules. It is a signal that the future of tech must be built on trust, transparency, and shared values. And if we embrace that, BC can lead not just in Canada, but on the global stage. And those are like just a couple of words to get the conversation started today. And with that, Emily, I pass the virtual mic back to you. Thank you.
Thank you, Nadia. That's great. I love the idea technology people can trust. And that certainly has been a theme that's been coming up in some of the conversations I think many of us have been having recently. That this, in fact, can help support innovation. And so this is a great opportunity then to turn our discussion to Gerard de Graaf. So welcome. Let me introduce him properly. He is the Senior EU Envoy for Digital and head of the EU office in San Francisco. So if you'll join me now, I'm going to ask Gerard a few questions, and he's going to kind of walk us through some of the key things that that we should know as Canadians and innovators about the Digital Services Act?
Thank you, Emily, and good morning if you're on the West Coast, and good afternoon if you're on the East Coast. I'm on the West Coast, like you, in San Francisco, heading the EU office here. And before I was in Brussels in the European Commission, leading the work on the Digital Services Act and the Digital Markets Act until its adoption in 2022. I mean, the history of the Digital Services Act goes back a little longer than 2022 or 2020, actually about 10 years ago. The European Union started to ask itself, the policymakers, but also people, I mean, the stakeholders, like, well, how can we make the internet more safe? How can we ensure that our values, our fundamental rights are protected online as well as they are offline? How can we ensure that what is illegal offline is also illegal online? So these questions came to the surface, and we started to reflect on, like, well, what should we be doing to ensure this? And at the same time, we also saw that some of our member states were kind of getting into this space and regulating. And so the European market, the single market, 450 million users, consumers, were beginning to become fragmented. There are different rules and different provisions in different member states. We had tried self-regulation. We had worked with big tech platforms and on hate speech and on a number of other issues, but we did not see the full positive results from that. So we came to the conclusion that we had to intervene through regulation. And so we began to shape that, and we made the proposal in 2020. And the approach which we decided upon was an approach which we actually we had looked at the banking sector, where you see also like this issue of systemic risk. I mean, impacts that kind of ripple through society very quickly across the European Union. So it's a European problem. And we saw like a systemic approach in the banking sector around risk management, know your business customer. I mean, we saw some concept there that we thought were actually quite relevant in the context of internet and internet platforms. And so we started to work on that and ended up with like a Digital Services Act, which in effect is a transparency and accountability framework. Transparency because we did not really know how these platforms were like moderating content. How they were favoring certain kind of types of content through the algorithms over other types of content, how they were removing content. So there was it was effectively like a black hole. And there was very limited, if any, accountability if the platforms got it wrong or decisions that were kind of inconsistent with our laws and our fundamental rights. So what have we what's the DSA about when you go into a little bit more of the detail? It sets out obligations. And these obligations are actually symmetric. So in the sense, if you're a very large platform and therefore your impact on society is bigger, you should have more obligations. If you're a smaller platform or you are a platform that or an operator that's a little bit more away from, not user facing, you should have fewer obligations. And so we have that differentiation. And so the very big platforms, which we define in the European Union, very large online platforms as those that have more than 45 million users, which is a proxy, it's 10% of the European Union population, have a range of obligations. And then if you're smaller, you have more limited obligations. So what are, for example, these obligations? Well, transparency. You have to kind of inform the regulator and as such then also the users, how you are moderating content. How many kind of pieces of content have you removed? How many complaints have you received? What have you done with these complaints? How many moderators do you have? I mean, we have 23 languages in the European Union. Yeah, we talk a lot about English, but how are you moderating content in the Latvian languages, the Czech language, in the Portuguese language? So tell us how you are doing that. How many moderators do you have on each of these languages? So we do require these platforms to report about how they are moderating their content. We also require these platforms to do risk assessment. So they have to look at their systems and then kind of assess the risk on a number of dimensions. What is the risk that the system can be used to spread illegal content, terrorism content, illegal hate speech, child sexual abuse material? What's the risk for the protection of minors, their mental health? What's the risk for election interference? What's the risk that like defective products or that do not meet European standards are offered on marketplaces? So they have to do a serious risk assessment. The same banks do that. What's the risk that I will have a capital adequacy problem, a solvency problem? What's the risk that I will be used for money laundering purposes? And not only assess the risk, but then they also have to set out what are the measures that they will take in order to mitigate that risk. So that's an important obligation. They will have to do an annual risk assessment. And every time they introduce a new product, they will have to do a risk assessment before they introduce such a new product. We have other obligations. I think the interesting thing is that we rely a lot on like third parties. I mean, for example, notice and action. So every very large online platform needs to have a system where if you are as a user, you see something on that platform and you think it might be illegal or problematic, you can immediately notify that very easily. Say, I saw this on your platform. I think it's illegal. Please check it out. We call that a notice and action system because then the platform has to do something. And the interesting thing is we do have a liability exemption as well. You have it in the US, it's called Section 230, it's quite well known. We have a conditional liability exemption. So platforms are not responsible for content that users are uploading on their systems until such time as they have been informed that there might be a problem with it. So it's a knowledge standard. So if we as users tell a platform, I saw something on your platform, and I think it might be illegal, the platforms no longer can benefit from the liability exemption. And so if they do not act expeditiously. So that kind of creates a dynamic where platforms actually have to become active. They have to kind of check whether that content meets not only their own terms and conditions, but also meets the national laws of the countries in which and the European law in which they operate. So that's another obligation. We required very large online platforms to undergo a mandatory external independent audit, same as happens with companies, same as happens with banks. So auditors come in and check the systems, whether these systems are actually robust, that what the platforms report to us is actually credible. And that's also some kind of where like the external oversight gives us confidence that these platforms are taking their obligations seriously. Today, interestingly, there is a new obligation that has kicked in, which is an access to data, so data inside of the platform for researchers to be able to access and then to use it for their research in light of particular risks that they want to explore. And so altogether, there are some 15, 16 what we call due diligence obligations are kind of that's the kind of the content, the meat of the Digital Services Act. In terms of enforcement, which is of course always important, the enforcement for the very large online platforms, and there are about 20 or so of them, and you know them all, from Google to Meta to the Microsoft search engines, so social media companies, big marketplaces like Amazon, more recently porn platforms as well, are under the Digital Services Act, and they have more than 45 million users in the European Union, and that oversight is done by the European Commission. For the smaller platforms, the more local, regional platforms, the oversight is done by the national services coordinators. The enforcement can be pretty tough. It can be 6% of their global turnover in terms of fines. Obviously, we're not in the business just to collect fines. We're in the business to see compliance, but you need deterrence sometimes in order to get companies to comply. And there are a number of cases already that the European Commission has taken against some of these platforms in order to ensure that they comply. So that's in a nutshell the Digital Services Act. it's a differentiated kind of. The very large ones have more obligations. These obligations are kind of around transparency, risk management, external audit, access to data for researchers, notice and action, and that's what the platforms are now complying with in the European Union.
That is the perfect kind of overview of how the DSA works. And so what I'm going to do is introduce our panelists. And of course, you're one of the panelists. And I'm going to save a question for you later, but I'll just sort of toss it out there now to keep in mind is I'm interested to hear a little bit about the experience of implementation, because I know that there's been so much going on with that and lessons learned and growing pains that's just inevitable in creating something new. So I'll do the terrible thing and ask us to hold answering that question to a little bit later, and we'll loop in our panelists now. I'd like to introduce Rob Goring. He is the executive director of AI in BC, and has over 25 years working on founding and operating technology companies across a variety of sectors. So welcome, Rob. I'd like to also introduce Florian Martin Burrito. He is the University Research Chair in Technology and Society and director of the Center for Law, Technology, and Society at the University of Ottawa. And actually, we both are co-editing a book that is about to be published in probably the next few weeks on human-centric cybersecurity, called Security of Self. And then I'd also like to introduce Darren Thompson. He is the Chief Policy Officer, Policy and Legislation Team with the BC Ministry of the Attorney General. And I know that he has been deeply involved with so many of the digital policy files for the BC government over the years. So welcome, everybody. And I think my first step for the panel would be to turn to you, Florian. Because if viewers may or may not know, Florian is from France, and so he has this kind of unique perspective of both the EU and Canada. So after Gerard's, given this wonderful overview of the DSA, I'm interested to hear from you. As Blair mentioned earlier on, he said, well, one of the questions is what are the lessons that can be learned for Canada about the DSA? And so I wanted to ask you about that. What are these lessons? What should be the lessons here? How should we be thinking about the Digital Services Act in Canada?
Perfect. Thank you so much, Emily. I was not expecting that big question from the get-go, but we can go. But first,
I just thought we'd jump in.
No, I can go for 2 hours just on this, so But so first, thank you so much for the invitation. I'm delighted to be with you today, and I really appreciated all of the kind of introduction, setting out the context, and as also Nadia highlighted, regulation, law can help build trust and level also the playing field, be beyond the different actors in the ecosystem. That was one of the key objective of the set of EU acts and regulation that have been passed in the past years, and kind of and also use it as a roadmap around the world. But I would like to insist, and also it's also I think a very important lesson learned for Canada coming from the EU is the DSA that has been explained is just one of the pieces of legislation that exists in the EU to regulate digital context. It kind of needs to be read with the infamous GDPR about privacy, but also the Digital Market Act about more competition and the ecosystem, the DSA that is about the platform and on more systemic level. Then we have also the latest in the series, the AI Act, that's more on the tools, so way more specific and granular, with a set of other directives and regulations, etc., that are being passed over the years. So it's a very rich, but also complex ecosystem of rules. And I'm very impressed. Gerard, in just in a few minutes, I've been able to kind of explain all the complexity of the of the DSA, and maybe just also to tease out a few elements for the attendees that might be not familiar, and that might question why, like, throughout the end, Gerard was mentioning like Amazon, because often, the DSA is seen as kind of just content moderation for social media, for like TikTok, Facebook. We kind of heard a bit about like search engines, so it covers like Google and stuff. But so that's something very important to take into account, is that the DSA is not just content moderation as we usually, think about it with the usual social media. It's about like any kind of online content, including the goods, that are like sell on platforms, ads, etc. So on social media, but also on online marketplaces. And that's why like Amazon is kind of one of the targeted platform by the DSA because of its this reach. It's also all of the pornographic, websites, all of the app stores, and also like all of the search engines, as I mentioned earlier, with that kind of layers of responsibility depending on your size. Like, so the very large one have way more obligation, medium one have like less obligation, but still like rules about like transparency and kind of bringing, I think also Nadia was mentioning it, like, accountability in the way you design this, with this idea of kind of like safety by design for consumers, for users in the EU, but also beyond the EU, because anybody who wants to deal with the EU market, that is a very interesting one, I would say, for Canadians, need to comply with those rules. So that kind of help to level the and like bring a higher level of protection around the world. It's very like it's a lot of work for companies for sure to like comply with those rules, but I would say it's often like a gold standard. But there are also like a lot of those provision, like some of those provision, macro and small enterprise, so very like the small, like kind of like the mom and pop shops, are excluded from some of the complex provision to make sure it's good for kind of everybody. So another thing I would like to highlight, and I think Canada should learn about this when we think about the new bill that might soon be introduced. It's about everything else that's covered by the DSA. So as mentioned, it's also about like goods, counterfeit, products available on those platform, with obligation for businesses to trace the, who is selling what, the kind of product. There is a lot of rules about like advertisement, and we know it's a big issue with platforms. It's a source of like online harm, of scams with cryptocurrencies and others. There's been like a few stories lately in North America. So there is like transparency requirements about who is placing the ads, why you seeing the ad, those kind of information. But also there are like ban or kind of ads you can display with like sensitive topic about sexuality, religions, race, and also a ban on targeted advertising that is targeted toward children's based on the data. And we've seen with some of the chatbot being promoted toward like the kids, and some of the awful stories that we learn about in the past week or months. I think that's a very interesting thing that maybe Canada could learn about. There are also rules about e-commerce, so for Amazon, etc., with clear rules for what is made available for like some age group or so, or you provide the information about the recommenders, Amazon and others, Zolando, etc., promoting sometimes their own product or some specific products, rules about dark patterns, so like those manipulative tactics for the design of the platform that can impair on the decision making of the users. So there's a lot of things that are also included in the DSA beyond just content moderation at the systemic level, which I think are like super interesting and very helpful to protect users online, and that we should learn from. But also we should not just copy paste the DSA, and we should not just do the DSA. First, like Canada need to update, as it was mentioned by many people already, the privacy framework. Although BC is leading, like BC, Quebec have been leading the charge, but yet a lot needs to be done. We need to protect whistleblowers. A key things also in the DSA is, and in the set of EU acts, is the protection of whistleblowers. We're like able to raise the alarm bell around this. Consumer protection is key and really needed. We need an update of this in Canada. And I think the biggest lesson learned from the EU for Canada is that you can have a piece of legislation, the best one, but if you don't have enforcement, the market will not follow. And this is something that is missing, deeply missing at the federal level, at least in Canada, is like any enforcement for our regulators with automaking power, etc. So I will stop here for those remarks. I think I already spoke way too long, but that was kind of like my first reflection on what was said this morning.
No, that is, I think that's great. And that gets us going with thinking about some of these key issues. And bouncing around my head was who has ownership of some of this. Like, I think it's key that advertising is addressed. And I wondered, oh, should this go? I mean, the natural home would be the Competition Bureau, but also a lot of this online platform ecosystem is sort of one ecosystem. It would be great to have a regulator who's knee deep in this that could lead on this. But I won't go down this rabbit hole. I am a moderator, and I remind myself to stay a moderator. So what I'd love to do is kind of look a bit closer to at the innovation sector and also just some of the approaches in BC we've been talking about. So I'd love to talk with you, Rob, because I mean, you're leading it for helping facilitate the innovation sector. And there's been some, like Nadia was talking a bit about, what is needed, what's kind of needed to help spur that. So why don't you, I mean, I'd love to hear from you a bit about the innovation sector in BC and what is going on there and why the Digital Services Act is relevant.
No, absolutely. Thanks very much, everyone. It's a great conversation already. I think BC is very interesting in terms of the overall tech market. We have over 11,000 technology businesses in British Columbia, employing close to 200,000 people. 80+% of those would be recognized as a small business, 10 people or fewer. And what's very interesting about British Columbia too is the diversity of the industries that are served. Everything from mining and ag tech and sustainable energy, all the way through to typical software as a service businesses and on and on and on. From an AI standpoint, we have now more than 600 AI companies in British Columbia. But when we do think about AI, again, in BC, it's very much around what we often call applied AI. We are less about building large language models and much more about building technology with AI that is changing the sort of face of business. So I think what's very, very important are a couple of themes here. One is that I always agree with Nadia, otherwise she gets mad at me, but I think what she said earlier was excellent. I think we are seeing a very strong opportunity for the mentality and approach to the DSA and other regulatory environments in the EU as a competitive advantage. I think with the geopolitical environment we find ourselves in, traditionally in British Columbia, it has been just so easy to drive 2 hours south of the border to Seattle, the home of Amazon and Microsoft and others, 2-hour flight to where Gerard is and San Fran. It's very easy to kind of stay on the West Coast here and do and grow your business. Things have changed. It's become a lot more difficult to have certainty around where business is going to come from. And I think we are seeing a very, very rapid expansion of interest and opportunity between Canada and British Columbia and the EU. I can tell you that from our, the AI companies, everyone is extremely interested in learning about this topic and the adjacent topics on how to do business in the EU. We had a contingent at Vivatech in Paris in June. There were 22 British Columbia companies there out of the Canadian contingent. Had the opportunity to meet with a lot of folks, and out of that, there is huge interest. We've got a team of people going to Lisbon for Web Summit in a couple of weeks as well that are very interested in figuring this out. So I think what a lot of the things that have been talked about are very, very important because when we hear about the DSA, often is the very large online platforms. You hear about the TikToks and the Metas and the Fines and things. And while there are exceptions for small businesses, you can't just bury your head in the sand and expect that you can enter a market without an understanding of the frameworks you have to get involved in. The other hat I wear, just out of interest, is I have an early stage startup company called Wiser. We do third-party supply chain cybersecurity risk. So we deal with all sorts of the compliance frameworks from SOC and ISO 27001 to NIST and everything else. So this also is very near and dear to my heart from a compliance standpoint. And I think what's very, very important and powerful in these conversations is the ability to provide the businesses the bright line tests and frameworks to know how to operate, in the EU and how to interoperate between what is regulated in Canada, the EU, and other countries. The thing that often comes up is, what does this cost? And I think, again, in an economy of mostly small, medium businesses, that can be a real factor. Do you have to spend $5,000 or $150,000 to figure out your compliance framework in order to do business? So I think education is very, very important. And I think the opportunity is really massive. And again, back to what Nadia said, this is a strategic imperative and advantage for companies that want to expand, to learn how to do this, get on the right side of the frameworks and the compliance, and then step into a market that we've found in the EU with open arms to do business. So I think that I'll pause there, but I think it's very, very germane to where the world is now and where it's going.
Yeah, it's interesting that you bring an interesting perspective to this, and it kind of it resonates when I think through conversations I've had with some of the different platforms that are trying to comply, and some of the description, I guess, even from the regulator side, is coherence, that you want to have different jurisdictions have almost you will have differences between what Canada does and the EU, but the same basic approach. And if there's certain, say, transparency obligations, having commonality between them so that the compliance exercise doesn't overburden a company for no reason when the goal is meaningful compliance. And so I keep thinking through what meaningful compliance would look like for the Canadian version to align and facilitate business with the EU marketplace. Okay, we will come back to you. What I'd like to do is turn now to Darren. Darren, as I mentioned before, has been Chief Policy Officer with the BC government, has had, many different, I guess, experiences in both trying to develop, he's led in development of legislation on intimate images and implementing that for BC, as well as other efforts to kind of negotiate and work with the online platform. So Darren, if I can turn to you and kind of say, well, what has been your experience with that and the approach that BC has taken and the opportunities and challenges in trying to address online harms and platform accountability?
Yeah, you bet. Thanks, Emily. And thanks to the organizers for the invitation to participate and for everybody who's tuning in today. I can share a story about the current policy landscape that I think is indicative of some of the trends that we're seeing in this area. And what happened was, in the last few days, our legislature moved a bill past third reading, and the bill relates to the still relatively new intimate images regime that BC launched a short time ago. And this is the regime to provide redress for victims of non-consensual intimate images. This regime is very built around victims. It's built around access. It has a very low bar. 14-year-olds can start their own legal proceedings without an adult, and everything can be done on a cell phone. So it's all about access. Protection orders can be made by a specialized tribunal very quickly. Fastest ones happen in a day or two. It also includes some powerful enforcement mechanisms, including large monetary penalties that could be made against online platforms who run afoul of the legislation. So the interesting thing that happened with this bill, which was just making some amendments to that regime to bring in some new improvements, is that the opposition party in our legislature proposed an amendment that actually went further than the government's proposal. It expanded the rights of redress for victims. And the government accepted it and supported the proposed amendment. So this should be a good indicator that there's bipartisan, or I guess in BC's case, multi-partisan support for this kind of policy response in this area. And I think that's part of a small example of this wider growing recognition of the need to address online harms and online safety, at least from a North American perspective. In BC, we've had multiple very high-profile tragic deaths of young people that really have captured the public's attention and brought a lot of focus on what's happening online and what could be done in terms of safety. And I know BC, again, is not unique in this respect. We've seen other provinces who have also passed, in particular, non-consensual intimate image legislation, and I've also started looking at other types of harm. We've also noticed that things are happening, or at least they're up and down, it seems, a little bit in the United States. Some of the efforts to regulate through legislation, also some of the lawsuits that governments are now initiating against people who are providing online platforms and other things to try and address some of the harms. The BC had its own bill that it was introduced in an earlier session that was positioned to open the way to go after corporations who do business in British Columbia and cause health-related harms. And the bill would have enabled the government to go after companies to get recovery of the public healthcare costs of treating people who suffered harms using the products. That bill was paused. It led to some discussions. It set the stage for some discussions with some of the largest online platform providers. But what I'll just say about the and what everybody I think will recognize is pretty obvious is that trying to regulate through litigation and large scale litigation involving governments is far from ideal. It creates a lot of uncertainty for all the actors, for governments, but also for the businesses. It can add a lot of cost, and it takes a lot of time and energy battling things out in court. What is much better approach, at least in my personal view, is regulatory models that are about safety by design and setting up an environment, changing the environment that in ways that avoids or heads off as much as possible, if we're being realistic, some of the harms that could cause. So if you keep all of this in mind, then the next question is, well, what do we think governments, if we're still looking at the policy landscape, what do we think governments might do next? Well, smaller jurisdictions like who are provinces in Canada, at least provinces like British Columbia, we are aware that we might not have all the tools or the levers that we need when it comes to dealing with massive companies who operate across borders. So one of the things that is fairly common is to talk to other jurisdictions to find ways to collaborate. So in BC, for British Columbia, that might mean collaborating with other provinces. That will mean talking to the government of Canada as well, seeing if there are ways, I think, Emily, you alluded to this a minute ago, to bring some sort of uniform approach, harmonization. That could be beneficial to actors in the space in the private sector, because then they don't have to worry about all the differences across jurisdictions. But it can also be advantageous for the jurisdictions themselves who are trying to regulate, because they can bring a little more weight to their efforts to address some of these issues. I can imagine a future where there could even be collaboration between provinces and other governments internationally, or at least constitutionally. That would probably have to happen through our federal government, but governments who may reach a point and say, We can't put up with this anymore. It's just intolerable. Some of the harms and some of the things that are happening, we need to really join together in a more serious way. I think these discussions that we're having today create very fertile ground for that. And maybe this is an indication of that effort that's starting to happen to join forces, I guess, or again, collaborate in a productive way. So if I guess when I try and put myself in the position of someone who's trying to innovate in this area in the private sector, I think it could be really easy to just see this all as fairly negative, and think like, oh, there's going to be all this new regulation. It's going to get in the way. It's going to be challenging for me. But I don't think it has to be that way. I hope that you could look at what the next 2 years and the next 5 years has in store and start asking the questions and saying, what could we do now to start changing the way we design our products or the way we deliver our products so that it will have compliance. It won't be a lot of extra work for us or a big hit to our bottom line in order to conform to the new requirements that might be out there. And maybe if you are taking that forward-looking view, maybe you'll find ways and opportunities where you can actually be part of the conversation that governments are having right now and help to steer where those conversations go and provide some of the opportunity that might come from the private sector that governments find really interesting and want to pursue. Again, I think this kind of meeting that we're having today is probably a good example for that. For the smaller companies, once again, maybe there's opportunities to join together in different associations and research groups, and once again figure out ways where they can collaborate and have a bigger voice at the table, including with governments who are contemplating regulation. So last thing I'll say to bring it back more to the topic is, where do we think all these governments and these efforts to regulate might go? Well, I think it should be obvious that the Digital Services Act that the EU seems to have been a leader in many respects in this area. It also has the size of the single market to have the influence out there in the policy landscape. So I think other people have already mentioned or acknowledged that it's kind of a standard that others will look towards and say, okay, what insights can we draw from this? What models have we seen used in these other jurisdictions that seem to have worked to address harm, to promote transparency, to have compliance, all of those sorts of things. So it should be, I think, fairly obvious that many of us are looking to the EU, so that I think it's reasonable to, as you're taking your 2-year, 5-year forward-looking view of what the policy landscape might be, is to say this could be a model that we should start thinking seriously about, and what we can do to comply now. So thank you, Emily. Those are my initial thoughts.
No, it's great, Darren, and I think it's, I find I kind of think through many of those same things of, if you cast your mind to the future 10 years from now, or even 5 years from now, what does that environment look like? And, you can imagine a space where there's something more embedded in Canada, both federally and provincially, much like we're seeing with privacy commissioners, and globally, more collaboration and conversation. I mean, we're seeing the development of that global online regulators network, starting to have those conversations, but it's still very much early days. The final point I'll just say is that, it made me think too that what we're hearing often from businesses in Canada, and I'm thinking here particularly about AI, is the discussion that right now, Canada is an uncertain place to be innovating, doing business, when they don't know what the rules are or are going to be. So in fact, rules can create a sense of certainty about innovation. And looking outward, what are the markets you want to be aligning with? Well, then that gives you a sense of the kinds of frameworks you want to be developing here. So I abuse my moderator privileges, but what I would like to do is turn then to Gerard. I mean, you kicked us off, and I know I'm conscious of time and that we started late, so I think actually I'll go to Q&A after this to see if we have any. But Gerard, I want to turn to you because I think you probably have some reactions or responses or thoughts on some of these points. And remember, I mentioned implementation if you do have time to talk about that.
Yeah, thank you, Emily. I mean, I think excellent points that were made by I think all of the speakers before. I think trust is really important in this area. I mean, if consumers don't trust, if users don't trust, markets will never flourish in an area. I mean, take AI. If people are apprehensive about AI and these applications, they don't trust it, the market will never reach its full potential. Predictability, I think a point you just made. I mean, this country where I am kind of posted, I mean, a lot of the industry is kind of uncertain about what the future might hold in terms of rules, I mean, regulations, in terms of tariffs, etc., and holding back on investment. So, I mean, uncertainty is a real barrier to innovation and to investment. So that if you have a predictable framework, of course, you mustn't go over the top. It actually does help because it gives you the confidence that if you invest, then you can get a return on that investment if you comply with these rules. I think from a kind of what are the lessons learned from our perspective, I think asymmetry is really important so that it's risk-based, so you need to focus on the risk and you need to focus on the ones that are kind of, say, the biggest in the market. And try to, I think, to limit, if not completely avoid, regulatory burdens on the really smaller micro enterprises. And that's what the DSA does. It has this kind of differentiated approach. I think in general, we're not inventing something that is not derived from good practice. I mean, typically, if you do the right thing in life, you should be in order with the law. And so a lot of actually what is in the DSA are things that many platforms are already doing, not necessarily all of them. And so we have basically codified this transparency, risk management. I mean, the kind of access to data. So, in a way, I think it's generalizing best practice and then codifying it, making it mandatory. And so it is not something that kind of, if you are a good business and you want to run a business in a way that kind of is kind of trustworthy. The rules should not, it'd be odd if the rules suddenly would kind of require you to do other things. So because it's based on, say, a common sense approach. And one set of rules, again, from the perspective of predictability. I mean, the European Union, 27 member states, they have their own regulatory, they will regulate. And so what we can offer now also to companies from Canada is a single legal framework. There's one set of rules, DSA, AI, GDPR, you comply with these rules, you have access to the whole of the internal market. You often hear in this country, oh, well, no rules. Well, what's happening at the moment in the US is that the US states are setting the rules. If you take AI, for example, maybe no rules at the federal level. 120 laws have been enacted already at the state level. In the state where we are located in California, there's 27 AI acts already in place. One is actually quite similar to the EU AI Act. So you have this like patchwork of rules and regulations that, particularly for the smaller companies, is very difficult to navigate. I mean, if you're a small growing company, the first person you want to hire, with all respect, I'm not a lawyer, is not a lawyer. You want to hire like a a software programmer or somebody who sells your product, but not to somebody who kind of is actually kind of overhead to your and adding cost to the operation of your business. So those are like all kind of, I think, considerations to bear in mind. So think about asymmetry. Think about like having like a single framework rather than multiple frameworks. And then the important point is enforcement. Excuse me. The companies that we are facing here, and not all of them, of course, are American. We also have Chinese companies within the scope. We have we have some Indian companies within the scope. We have some European companies in the scope, even some Canadian companies in scope in terms of porn platforms. I mean, they are pretty strong. I mean, they have huge resources. I mean, we are in meetings with like 20, 30 lawyers from these companies. So you need to have like very strong capacity in order to enforce the DSA or the EU AI Act. That's why we are setting up, and we have set up specific enforcement structures. I mean, if you look at the DSA, we have a team of now 200 people who are enforcing the DSA. We are like 120, 130 people growing to 200 people for the EU AI Act. So you need to have that capacity because this is not easy to enforce the legislation. I mean, what I think if you're looking at it, like what could be the things that Canada would be looking for? I mean, I think transparency is very important. And I think the argument here is if they can be transparent towards the European Union, why can't they be transparent towards Canadian users? I mean, how are they moderating content in Canada? And I think the same for risk management. If they're managing the risk towards European users, why can these same platforms not manage who are operating quite extensively in your country? Why can't they manage the risk for Canadian users? That just doesn't seem to make sense. So I think those are their issues. I mean, in a way, the DSA is modular. You don't have to do everything. These are like 15, 16 due diligence obligations. I mean, you can take 2 or 3 and then build on it. And you go further as you kind of gain more experience. In terms of the implementation and the enforcement, I think the first thing is and this is hard. I mean, these companies have not got like the real tradition of being regulated industries. They don't feel like the banking industry or the energy companies or telecom companies or healthcare companies. They have not traditionally been regulated, particularly in this area of the world. Also, like Silicon Valley, where I'm based, I mean, there's quite a libertarian streak. As you remember, the move fast and break things. So one of the things that really is like almost a cultural change here of these companies is to recognize that they have become regulated industries. And they have to put systems in place. They have to kind of change cultures inside the companies in order to comply with these regulations. And that's not easy. And I think particularly in the current political climate, I mean, there is quite some pushback. I'm sure you will have noticed that against the DSA and the DMA and the EU AI Act. But I mean, we have the regulatory autonomy in the European Union. We are regulating in a way that kind of is consistent with our values, consistent with our interests. So we will enforce the law. We will enforce it fairly. But that, I think, that kind of like change of approach, change of attitude in these big platforms, that they have become a regulated industry, that still takes a little bit of time. I mean, we do see improvements. It's much, I mean, the transparency, I mean, is very interesting and helpful to see. We can also, for example, see that in some member states, that they were not really moderating. I mean, for example, before elections, I mean, in countries like Slovakia or the Czech Republic, they had 1 or 2 moderators that were actually capable of understanding or speaking Slovak or the Czech language or the Romanian language. So these are kind of issues that also then beforehand we can address with these platforms so that they beef the capacity up, certainly in advance of very important elections that are taking place. So we have a much better grip on the transparency side. I mean, we also, in terms of like the justification, whenever a platform now removes content, it will have to give reasons, and it will have to publicly kind of give these reasons also to the one person that like uploaded the content that they have then decided to remove. And there's appeal procedure. So there is also, in that sense, I mean, actually, millions of Europeans are now using the right that they have to appeal decisions that their content is removed or demoted. And in 40-50% of cases, the content is put back as a result. So there are like these very practical changes that are happening. Of course, we also have enforcement action. We have a number of cases that are kind of nearing the decision point. I mean, the aim is to get to compliance. The aim is not to impose fines. Of course, we may need to impose fines in order to get to compliance, but it's never the objective in itself. And so we do see that kind of the internet environment in Europe is becoming safer. We do see that kind of the values are better respected, and we do see that the companies, sometimes grudgingly, it's certainly also a spectrum. Some companies are like more forthcoming than other companies, are kind of putting them in compliance, putting themselves into compliance with the European Union law. But it does take a little bit of time, and we may also need to have like decisions with like that might then be litigated in court. So there's a variety of situations, but the overall, I mean, definitely we believe that the DSA has been having positive impact on, say, the climate and the environment for trust and safety in the European Union in regards to social media, also marketplaces and search engines. So marketplaces, for example, illegal goods. We have worked very closely with also Chinese marketplaces, AliExpress in China, and also with Amazon. And so there's a much more rigorous approach of these platforms to avoid users in the European Union to be scammed or to buy products that are unsafe and could actually harm them. So it's definitely improvement there.
Can I just tease out one question, because I think the EU has actually implemented that individuals can, in essence, appeal a moderation decision to a tribunal, which is unique. And I can say that the advice was against that in Canada, at least to those of us that were expressing opinions on that, just because of the capacity to be able to do that. And it wasn't in what was proposed in the bill that died in Canada. So who knows what will be, hopefully a bill will be reintroduced. And I doubt that that kind of appeal mechanism would be introduced. How is it working now in the EU? I mean, is it, I think it might be useful for those who are watching to understand this just a little bit better.
Yeah. No, I mean, it's producing positive effects. I mean, this obligation only applies to the very large online platforms. So again, you're talking about kind of organizations that definitely have the resources and the capacity to engage with users and try to find solutions to problems. So we're not imposing this to the whole population of digital service providers that are captured by the DSA. I think that's important. What we also so there's an internal dispute resolution system which kind of users should use first. So they first go to the company and say, look, I see you have, because companies need to notify the users that they have taken down certain content. So the user is aware, I posted this, has been taken down. The user is aware the grounds for which the company, so the platform, took the content down, and then they can challenge that. So they challenge it first internally. If that's not successful, they can go to an independent external mechanism. And we have now, this is actually like a market that is developing. There are already 5 like operating across the European Union, 5 like providers of these kind of alternative dispute resolution systems in the European Union, and they will then mediate at no cost to the user. So that's kind of, so there's no barrier to try to enforce your rights. And we see that millions, I think we have got 17 million cases have already gone through that system since the DSA has entered into force. And in about 45% of cases, actually the user won. So the content was pulled back. And so that we think is an important kind of part also of like ensuring that our fundamental rights, our freedom of expression. I mean, in this country, the DSA is often portrayed by some as a censorship tool. Well, it couldn't be further from the truth. This is actually, I mean, and maybe adding some other figures here, 99% of content that is removed by platforms themselves on the basis of terms and conditions of the platforms. And so, because there's often this like government and kind of intervening and telling platforms to remove certain content, 1% is removed following this notice and action system, where the users are saying, well, wait a second, I see something and I think it might be illegal. And then the platform acts. Again, it doesn't necessarily take down all of the content in response to such a notice and action, but in many cases, again, users have a point and they come across content that is not legal It's not this is purely in the DSA is about illegal content. There is absolutely no obligation to remove content that is not illegal, and what typically is called it's awful but lawful. And so those systems were actually, and this is, I think, also important from an enforcement perspective. We've also always presented the DSA not as like an enforcement, like a central enforcement European Union with regard to the platforms. This is a multi-layer enforcement system. The users themselves can enforce the law. They have been given rights. They can enforce the law. They can also take the platforms to the court. They have a legal basis to take platforms to a court. Researchers like yourselves, I mean, you can go and dig deep into data that the platforms would not voluntarily make available, but now they are obliged to make it available in order to do research and, for example, find information about how platforms moderate content in advance of elections, for example. The external auditors coming in, independent, looking into like all the kind of cupboards of the platforms and talking to lots of people, also kind of verifying that the platforms are actually kind of complying. And then NGOs that look at the transparency reporting and everything else. So there's so much material that is now being available that previously wasn't. We had no idea. It was a black box. Nobody knew how platforms were moderating content. Nobody knew how platforms were doing the risk assessment, if they were doing risk assessments at all. So I think that kind of multi-layer approach where everybody in effect can just collectively ensure that the internet and social media marketplaces and search engines, etc., are becoming safer, are operating in consistently with our values and with our fundamental rights as we have them in the European Union, as you have them in Canada. We think that is a very important step forward.
Excellent. So what I'm going to do is if anyone who is watching this has any questions, feel free to post those now. In the meantime, I thought I'd also turn back to the panelists. And, we've heard so many things. If there was anything in particular that you were thinking about that you wanted to add to the discussion, you can jump in. Otherwise, I'm going to start picking you one by one with all my particular questions. Florian, I see you're ready.
Yes. But also, if you have a specific question, I'm happy to answer. But I wanted to maybe kind of like double down on a few things that George just said, and again, like what we can learn from Canada. And he mentioned the case of California that is has been very active for data protection, AI regulation in health, etc. And I think it's important to keep this in mind because very often when we talk about the DSA, the GMN, other things, and even in back here, like in Canada, when we talked about the different proposal, you often hear the narrative of regulation stifles innovation. I don't think we can say that there is no innovation happening in California. I think California is known to be like a state of innovation. The same goes now in Canada for BC and Quebec, who has been leading on the regulatory side for decades. And I don't think we can say that those two provinces of lagging behind the others in Canada when it comes to innovation. So I think it's something to keep in mind. And as at the national level, we talk a lot about adoption, about sovereignty for Canada in the digital space. Those kind of regulation will help for adoption because they bring trust. They bring, as you mentioned earlier, the necessary certainty about the rules, the liability framework, what you can do, the rule of the games. They will help with adoption, within government, within enterprises, by users for deployment, and making sure that Canadian businesses at the same level than foreign businesses, and that everybody has to respect the rule of the game. And maybe sometimes Canadian businesses would want to be more fair than other businesses that would not be subject to those rules. So I think this is super important to keep in mind, and I do believe that should be part of the one economy, one Canada approach and going to this. Yeah, the EU offer a single legal framework. We cannot offer this in Canada, even for our own businesses. This is a big issue, when we think about the Canadian leadership and adoption. And this is something that we need to work on. In my opinion, like you were mentioning privacy, like, the federal level, provincial and territorial level have been working together to try to kind of make more sense. And, as Jerome mentioned, like in the EU, most of the rules are kind of more like common sense. So they were like better understand, I would say, but by the public and by the industry. But so you need to be coherent. We don't need to do transplants, but we need to be current with what is happening, around the world, also within Canada. But we need that collaboration between the levels of governments, but also between domains. So like building capacity, as again, Jared was mentioning, but also like one of the key issue at the moment we have in Canada is, and this is something that the regulators are often flagging, they cannot really like fully work together. Like in the privacy domain, like between the level, they kind of work, and often the federal regulator work with BC, Alberta, and Quebec because those provincial regulators have actual powers. But we need the privacy commissioner to be able to work with the competition bureau and any other regulator that might be introduced. This is something that was proposed in the previous bills, and I think this is essential because it requires a wall of government approach, a wall of country approach, but also a wall of regulators approach to make sure that we tackle like those complex issues from like all of the available sides to protect like Canadians. So I will stop here because I could go for hours, as you know. But yeah, that was like the key remarks I wanted to share after the different remarks we heard.
Yeah, and I think I remember looking at Bill C-63, and I don't remember the details on this particular aspect, but that there were challenges with the way that the information sharing had been structured about what information they would be able to receive and share with other regulators, because I remember thinking that it didn't have all the key players that were going to have to be part of that collaboration and communication. And so there's all these granular things that are so critical to make any of this work. With the few minutes, I think that we have time to go a few extra minutes because we started late, I believe, but the organizers can message me loudly if this is incorrect in my assumption. But I have, I guess, a few questions left. We have one question from the audience, and I want to turn quickly to Rob and Darren as well. So maybe Darren, quickly, I want to turn to you about this, the uniqueness of Canada with the division of powers, that to actually address this. I mean, I keep thinking this has to be led federally for that collaboration, but also there's necessarily some things that have to be within provincial domain that maybe aren't quite understood by the public. So if I can just kick that to you briefly.
Sure, thanks. Loosely speaking, the way we approach these sorts of things is we've got the Canada's Constitution Act 1867 divides up powers, divides responsibilities between the federal government and the provinces. And communications is one that we our operating assumption now that this isn't an official BC government position that I'm sharing here or anything like that. And there can be ways to subdivide and reframe and innovate. But generally speaking, communications, federal responsibility, and then in this space, I guess you could say the provinces have policy levers that they can pull on providing redress for harm. So I talked about the intimate images regime that we built in BC. It's almost entirely, it takes a policy approach that's based on providing civil redress for victims. Just again, to bring it back, there's federal law made by the government of Canada in the criminal space that creates offenses for people who distribute non-consensual intimate images. So it's a good example where you could be the subject, if you're a wrongdoer, of this federal statute setting out the criminal law. But also in BC, we've got a civil statute that deals with it in a different way, but same subject matter. So other levers that the provinces can explore are consumer protection law. So it's something that our ministry actually recently became responsible for here in BC. So that might open up some avenues to regulate in this space. And generally, the administration of justice, a lot of that happens in the provinces. So I think there's opportunities out there where there could be, these Lego blocks of responsibility could be fit together, and we haven't done it yet, but we are always open to talking to other provinces. We've had some great conversations with the Government of Canada, and it's something that I think will continue.
Yeah, I like that. It is little Lego blocks, Lego blocks of online safety. So, Rob, I'm gonna just turn to you with, these kind of maybe final takeaways, thinking about it from the perspective of the innovators based on what we've been talking about today.
No, that's great. And I'll keep it pretty quick. I mean, I think, again, looking at the tapestry of the companies and organizations in Canada, if you're a small, medium business and you're growing and you want to expand, the regulatory framework around the world can be very daunting. So I think, again, these kind of conversations, just raising awareness and getting the fundamental understanding of what's required out there is very, very important. I think it's so much more important for organizations to start soon on these, like I think many people have said. And that's been proven true in other regulatory frameworks where you start early and you grow with it instead of having to retrofit on down the road or after you've been notified of a problem or something like that. I was early in the world of Castle and GDPR and all that when I took over an email marketing company, and that was we had to retrofit a bunch of stuff, and that was not fun. But I think that I'll leave with sort of an opportunity where I think we see an emergence of companies to fill these voids. If anyone has had to do HIPAA, GDPR, SOC 2, ISO 27001, and you did it manually, and then you've moved to a platform like a Drata, a Secure Frame, or a Vanta or something, and these tools now help you comply with multiple frameworks. You've complete one and you've got 60% overlap of another. So I think we're seeing an emergence of these tools, and I think my hope and belief is that as these things mature and as the requirements filter down from the very large online platforms to the smaller, we'll start to see tools come out that can help organizations complete a compliance program without too much heavy lifting. That's my fingers crossed. An innovator will innovate around this for sure.
I love that. Innovator will innovate. That's great. One, just very quick, Gerard, I want to turn to you with there was a question about measuring the impact of the Digital Services Act on protecting democracy, and was that mandated in the legislation? And if not, do you think impact assessments have to be performed on that? It does make me think more particularly about briefly those civic discourse provisions. I think that maybe that speaks to it in the DSA.
Yeah, I mean, that's of course, I mean, it's a very wide question. I mean, the DSA has an important role to play in promoting open civic discourse. I mean, in kind of line with our fundamental rights and particularly our freedom of expression. So this is certainly a contribution that the DSA is trying to make, but obviously in wider scope around democracy. I mean, there's so many other issues that come into play, from like education. I mean, making sure that governments deliver on the expectations of the citizens. I mean, democratic governments that just provide better quality solutions and higher kind of growth and better quality of life. I mean, that's the best way to promote democracy. And so you can't narrow down like democracy stands or falls on the success of the Digital Services Act. I mean, there's of course also other acts that were mentioned before in terms of legislation. I mean, GDPR, of course, very important here to protect our personal data, which is a fundamental right in the European Union. The AI Act to ensure that decisions taken, particularly by automated systems, are fair and non-discriminatory and kind of are in line with social justice. So, I mean, we as I mentioned, we are, of course, tracking very carefully what the impacts of the DSA is. We also are required under law to report on the impacts of the DSA to the legislator, to the co-legislators, to the European Parliament and to the Council of the European Union. And as I mentioned, I mean, transparency is a very important part of democracy. I mean, people need to see why decisions are taken. And if they disagree with these decisions, they need to have an avenue to to appeal those decisions. And those are like frameworks that are now offered by the DSA. And what we do see is that millions of Europeans are actually using those rights. And again, what we just talked about in terms of like putting the content back, 45% of cases, people see the content that was first removed by a platform to be put back. So that is good for freedom of expression. But we need a lot more than just the DSA. We mean, it's a massive, I think, the task and responsibility and challenge for like Western democracies in order to kind of continue to show that this is a much better model than the model that is being pushed by the populists that we also have in the European Union.
Thank you, Gerard. I think that's a good note to end on. I'm going to invite Kostas to come and provide closing remarks. And I just want to say from me, thank you everyone who joined in, for all of the speakers.
Thank you, Emily, and thanks a lot to all the speakers and the panelists. It is always challenging to come up with closing remarks after such a marvelous discussion. It has been very, very interesting. I hope that I enjoyed it very much. I learned a lot of things very much, and I hope also the attendees have enjoyed it and have learned a lot. Before closing, I would like to say two things. First of all, in addition to the fact that it has been a very, very interesting discussion, it has been also a very good activity, I think, action, this webinar, because it really gets into the line of our effort in the European Union delegation in Canada, which is based in Ottawa, to reach out as much as possible to Western provinces. And that's what we've been trying the last year. So I would like to point out that we're not only limiting ourselves to the Eastern provinces, but we are looking out to the thriving ecosystems in the West. And the second point is that, of course, we will continue this sort of initiatives. The EU delegation in Canada is here to help the Canadian authorities, especially in a very interesting and very fertile moment of internal reflection of the next steps in technology governance. We are here to help, and we are here to work together with our Canadian friends in full trust and in full alignment of our shared values. So that's what I had to say. More is to come, as we always say in the EU delegation, more activities, more engagement with stakeholders. I would like to thank you all. I would like to thank again the Canadian Heritage. I would like to thank the Digital Supercluster. I would like to thank the EU San Francisco office and Gerard de Graaf. I would like to thank the Chief Policy Officer and of the BC Ministry of Attorney General. And with that, I would say, keep tuned. More is to come. Thank you very much.